Hello, everyone, and welcome to the Labour Justice Barometer podcast. I'm Aisha Adam.
And I'm Debbie Collier.
And we're your hosts today on the Labour Justice Barometer. In today's episode, we're going to be talking about the Constitutional Court's decision in Van Wyk versus Minister of Employment and Labour. South Africa's parental leave and social security provisions have recently come under scrutiny in this case, where the Constitutional Court was asked to confirm an order of the High Court declaring that certain provisions of the Basic Conditions of Employment Act and the Unemployment Insurance Act are unconstitutional. As a self-employed birth mother, Ike Van Wyk falls outside the scope of statutory maternity protection and unemployment insurance benefits. Yet, rather than challenging the exclusion of self-employed mothers from social security protection, the Van Wyks pursued the recognition of caregiving rights for formerly employed fathers, such as Van Wyk. In this episode, we're going to explore what the court got right, what it missed, and why the judgment risks entrenching rather than dismantling structural inequality by leaving intact and, in effect, reinforcing the divide between those protected within formal employment and those excluded from it. And to discuss that today, we are joined by Professor Kitty Malebra from the University of Western Cape Law Faculty. Kitty teaches labour and social security law at both undergraduate and postgraduate level, and her research focuses heavily on social protection and social security rights, particularly of elder persons, persons with disabilities, domestic workers, and caregivers. Recently, Kitty and our very own Debbie co-authored an article on the Van Wyk judgment in the High Court. First of all, Debbie, welcome back. And Kitty, thank you so much for joining us today. We are very excited to have you.
Thanks, Asha. It's lovely to be back with you and great to have Kitty with us too.
Thanks. It's great to be here.
So let's dive right in. Kitty, yours and Debbie's article argues that the court in Van Wyk missed an opportunity to advance substantive equality, especially by failing to link the discrimination analysis to Section 27 on access to Social Security. Can you maybe walk us through why this omission is so significant for our listeners and what a proper equality Social Security analysis should have looked like?
Yes. On the facts of the case, there were two issues. The one is leave in terms of the Basic Conditions of Employment Act, which is not necessarily paid leave. And that, of course, immediately necessitates access to the scheme created by the Unemployment Insurance Act, which is access to Social Security. And it's this latter aspect that we were concerned with in our article. So whereas the discrimination analysis in the High Court judgment in the Van Wyk case was flawed in our view, as it was not based on substantive equality and also did not consider it from an equal access to Social Security angle, the Constitutional Court did not even try. It found it unnecessary to engage in an analysis of whether the provisions are discriminatory, whether the discrimination is unfair, and whether the provisions consequently are invalid. It merely found that they are invalid because the minister conceded that they are. And as the Constitutional Court is the custodian of our constitutional rights, we would have expected to at least consider the implications of the link between Section 27 of the Constitution and Section 9, and to provide guidance in this regard. So Section 27 provides that everyone has the right to have access to Social Security. In addition, subsection 2 requires the state to take reasonable legislative and other measures to progressively realize this right within its available resources. And therefore, the real question in terms of Section 27 and Section 9 is whether providing access to benefits, Social Security benefits, to birth mothers only and not to fathers as well is a reasonable legislative measure. And that ultimately is a substantive equality issue because when interpreting whether a specific statutory measure is reasonable in this context, the question is, why were benefits initially provided to birth mothers only? Why did maternity protection start only with birth mothers? And the court then could have built on its own precedent, such as Maslangu, where the intersectionality approach started, absolutely groundbreaking case for that reason. Yehu, where it was found that tackling the stereotype that mothers are the only caregivers of children, tackling that stereotype does not mean that it excludes special benefits for mothers. And then in Kosa versus Minister of Social Development, the test there for reasonableness and how to interpret Section 27 infringements in the context of equality and dignity that case and that judgment of the majority by Judge Mkhoro in Xhosa is the leading example of how one could interpret those three rights together. And if the Constitutional Court were to concede to any other authority, one would have hoped that it would refer to its, to the precedent that was created and not concede to the minister's interpretation.
Thanks, Kitty. I mean, I just want to take us back to what you said about, this being a substantive equality issue. And I mean, in your article, yours and Debbie's article, you argue that the court's reasoning reverted to a formal equality lens and overlooked this intersectional disadvantages highlighted, as you mentioned, in cases like Mkhlangu and Roberts. So maybe you can tell our listeners, why is this reversion so problematic for equality jurisprudence? And what does it risk entrenching in terms of social security law?
Well, I think Debbie can say more about what it risks in terms of substantive equality. In terms of social security law, it entrenches the recent trend of allowing social security law, and more importantly, the right to have access to social security, to fade into jurisprudential and maybe also legislative and policy obscurity. It started with the difficulty in Mkhlangu that the majority had in determining whether employment injury legislation is in fact social security legislation, which it is. But that trend has been continued, and that trend is quite dangerous for social security law in that very recently in 2023, the legislature created what is going to be the biggest social insurance fund in the country, the National Health Insurance Fund, without mentioning the right to have access to social security even once. It refers to the right to have access to healthcare, once again, to equality and to dignity. But it creates a social security fund, but does not refer to the right to have access to social security. Now, South Africa is one of only a few countries in the world where the right to have access to social security is entrenched in the Constitution. And if our courts, especially the Constitutional Court, neglects to include an analysis of rights in terms of Section 27 where it is applicable, if the issue at hand is access to social security, then that will just further this trend of social security law becoming an obscure branch of the law.
Debbie, do you have anything that you want to add to that in terms of what Kitty said?
Yeah, actually, I mean, I think in terms of the substantive equality implications of the Van Wyk judgment, the most problematic aspect of this, which Kitty mentions, is how the court has deviated, or not even deviated, just completely overlooked the asymmetrical nature of substantive equality. It requires us to take an asymmetrical lens in order to address, persistent inequalities and gender disparities. And just by failing to have a look at the dynamics from an asymmetrical perspective, I think is going to prove problematic unless the court picks up again on this aspect of substantive inequality.
I mean, Debbie, perhaps maybe you can talk us through here some of the practical implications of the judgment. Firstly, I mean, your article raises concerns about the court effectively rewriting parts of the BCA and the UIA. But how do you see the appropriate balance between judicial oversight and legislative reform within this context?
So I think separation of powers is a delicate balance and a difficult one to draw. But, in this case, it just seems that we've missed the point about the appropriate processes for law and policy development and reform and the possibility of overreach by the court. It's just unclear why they felt it appropriate, in effect, to rewrite pages of provisions of the Basic Conditions of Employment Act. And I mean, the Minister of Employment and Labour did make the point that the allocation of benefits, allocation of resources is preserved. It's a matter reserved for Parliament. These are political processes that should be involved, and processes in NEDLAC, and the Constitutional Court just didn't seem to be persuaded by this argument at all. And in fact, the argument that was advanced was that parents, being mothers and fathers, should get to decide who bears primary caregiving roles, and this in effect motivates for the provisions that are read into the Act, but it entirely misses the point which Kitty and I make about asymmetry. We're completely overlooking categories of workers, self-employed birth mothers like Mrs. Van Wyk, who are entirely excluded from the statutory protection. And the impact of the judgment just doesn't seem to be a factor or a consideration or a concern. There's no thought given to this practical impact and the possibility that this might have been a matter better left to political processes, and that these revisions should have been the outcome of lawmaking processes. I think it's quite significantly troubling, I think, from a separation of powers perspective.
You're listening to the Labour Justice Barometer, and we'll be right back. In a way, it almost seems that this kind of judicial intervention, wouldn't you say it actually slows down that broader reform by consuming this limited political and administrative capacity?
So, I think you're right, Asha. It raises questions around how we do law reform. This is, we'd probably label this type of litigation strategic litigation. Its use of capacity and resources. How was this litigation funded and the parties empowered to bring it? Because the reality is our Department of Employment and Labour has a wide mandate. It has limited capacity and resources. Is this the best way to engage their time and energy? There's a cost order against the department, even though the minister makes concessions. What does that budget impact mean for law reform processes? Is this the only provision of the Basic Conditions of Employment Act that should have been revised? No, there are others. But we've diverted all of this capacity and resource into providing equal provision for formerly employed men, to care for their children. So it raises all sorts of questions that, unfortunately, the court gives us no clarity or guidance on.
I think this also just sort of dives into my next question for Kitty or Debbie, whoever wants to jump in here. But your article highlights this exclusion of vulnerable categories of workers. And as we've said, it's many of whom are women, and they remain outside of the scope of the social security net. So what would you say are the most urgent policy or legislative steps that are needed to actually address the systemic exclusion?
Yeah, Asha, maybe just to jump in here, and Kitty might want to add. Of course, there were law reform processes under the South African Law Reform Commission for maternity and parental benefits for self-employed workers and workers in the informal economy. There are processes like this underway also at NEDLAC, which we've been party to in some ways. Certainly those processes are underway. So, I guess it gives rise to questions around whether this was a missed opportunity, whether there were other ways to catalyze existing efforts at extending social protection. Equally, the argument could be made that, this litigation was an appropriate way. Maybe the argument could be made that these processes were stuck. But still, I think we really have to take note that, we're looking at workers who are already in formal employment that are likely to benefit from employer policies around leave that are, in many cases, more generous than statutory. Maternity or parental leave is unpaid leave in terms of the statute, but many employers have more generous leave. And sometimes that is to promote the retention of women, for example. The impact of this judgment could have unintended consequences. Employers, we can have it's the wording of these provisions that have been read into the Basic Conditions of Employment. It imposes burdens on the employer to manage and monitor leave. It provides for how leave must be distributed if the two parents don't agree. And yet we see the argument that this is supposed to give power to the parents to decide who has caregiving, but it's in effect now shifting that burden onto the employer. So is an unintended consequence of this that employers are now going to claw back some of their generous leave provisions? I don't know. So I think all of these questions really should come out in discussion in lawmaking processes and other labor rights development forums, as opposed to litigation in the Constitutional Court. I do think that it's a very messy way to achieve law reform. And quite apart from the fact that there's this wholesale exclusion of vulnerable categories of workers, we're still not paying attention to their inclusion. How does this impact on their right to equal treatment and their dignity when really the court is focused on the dignity and rights of men in formal employment? So I think that of course, there are some benefits and certainly for some, this might be a very real impact. On the other hand, it also can, in a way, entrench privilege. Some families might be fortunate enough to have stay-at-home mothers, and in companies with generous leave provisions, this allows their husbands in formal, well-paid work possibly to also have the benefit of paid parental leave and both parents at home. But again, it drives that wedge between parents who have access to these sorts of paid forms of maternity and parental leave and those who continue to experience vulnerability and not be able to take on those caregiving roles in the same way. So I think, it probably, for me, raises more questions than it answers. Kitty, I don't know if you want to add anything to that.
I agree completely that the main priority is to get the reform process to ensure that all mothers have access to maternity protection and benefits as well. That needs to get back on track. It has been derailed a bit because the minister and the legislature has been given a very specific time limit within which this particular issue has to be addressed, which doesn't leave it that much leeway for other processes. But what I would like to add is that, ironically, the Constitutional Court has inadvertently bolstered one aspect of the law reform process to extend coverage to all mothers by dealing with the Department of Employment and Labour's available resources defence. Because, as you mentioned, the Constitutional Court has ordered that statutory amendments allow employed fathers, where they are the only employed parent, to get a full 4 months and 10 days, I think, benefit from the Unemployment Insurance Fund. So there should therefore be no financial harm to the fund in allowing the unaccount or informally employed mother to be included in that statutory scheme, because there would be no additional cost to the fund. It doesn't matter to the fund whether it pays into a father or a mother. It's the same amount over the same duration of the benefit. It's just split between them. So to a certain extent, part of the available resources argument has now been dealt a heavy blow by the Constitutional Court. The only remaining issue would be where both parents are informal workers or own account workers. There it would mean additional costs to the fund based on solidarity. And that fund is not a state budget fund. It is a solidarity risk pooling fund based on contributions by employers and employees. So I acknowledge that that may be an issue. But if the father is formally employed, there's no harm in the mother also sharing in the benefits, and the legislation can be amended to state that.
It's almost as if the court has, this judgment is actually risk creating a very fragmented system that just benefits some parents while leaving the most vulnerable community or the most vulnerable completely untouched. And as Debbie said, it's almost as if it's adding privilege to privilege, and that's a risk. And so I think that also leads me on to my next question, which is that's our final question, Kitty. It's something we like to do on the podcast, our Labour Justice Barometer podcast, where we actually look at our scale. And we say green is for meaningful progress, orange is for uneven or incomplete reform, and red is for a complete failure. So based on, our discussion today, where would you place South Africa's framework for maternity, parental, and social security protections after Van Wyk?
In my view, we were at orange. The Van Wyk judgment has tipped us a little bit more towards red. So I would go blood orangish.
That's a nice way to put it. Debbie, what about you? Do you agree with Kitty?
Yeah, I certainly don't think the judgment has tipped us from orange into green. I'm not sure what the shade would be there. But I do wonder, whether there would perhaps be some unintended consequences for equal protection for all workers. But yeah, I tend to agree, Asha, where this is although in many quarters this will certainly be seen to be a victory for equality, I think it does raise some questions, and so not quite tipping our Labour Justice Barometer in favour of Labour Justice.
Kitty, I mean, just based on your your answer to this saying blood orange, okay, let's say orange or red, what would it take in your view then to move this framework out of the red or orange? Would you say we need to, completely have a shift in how courts approach equality altogether? Maybe you can say a bit on this.
Well, I personally would think that we should have protection for parents. Family benefits should be taken out of the unemployment insurance system completely, because it affects so many aspects and so many rights. So that would be a start, going the route of all the foreign jurisprudence that was mentioned in the High Court case, where those countries do have separate family benefit systems. But yes, we would get closer to green if the derailed law reform processes that would ensure substantive equality are put back on track.
Thanks so much, Debbie. And thank you, Kitty. And I honestly can say this was a very enlightening topic, especially as we go into 2026. For our listeners, we'll actually be putting Debbie and Kitty's article in our description. So please feel free to take a read and leave them with your questions. We will link everything. Kitty, thank you so much for being a guest today. We hope you'll come back again soon.
Thank you to you and Debbie. It was a lovely opportunity, and I will definitely be back if I'm invited back. Thank you.
Oh, no, you'll definitely be invited back. Debbie, thank you so much, and I'll see you in the next one.
Thanks, Ursha. Thanks, Kitty. Look forward to seeing you again soon.
This podcast is not intended to constitute legal advice.